Okay, so chapter 3 talks about ethics, jurisprudence, and the Health Information Portability and Accountability Act, otherwise known as HIPAA. This starts on page 28 of your cengage dental assistant textbook. Some of the things that we'll be talking about is defining the Dental Practice Act and what it covers. We'll identify who oversees the Dental Practice Act and how licenses for the dental field is obtained. We'll define expanded functions as well as the components of a contract. We'll identify due care and give examples of malpractice, doctrine of res ipsa loquitur, and torts. We'll define fraud and where it may be seen. We'll identify the Good Samaritan Act, or excuse me, the Good Samaritan Law. We'll identify the 4 areas of the Americans with Disabilities Act, and we'll state how dentistry follows ethical principles in regard to advertising, professional fees and charges, and professional responsibilities and rights. So the laws of dental jurisprudence are laws that govern dentistry and are based on ethics that determine the guidelines of what is allowable, as well as determining the consequences for breaking the laws. Criminal and civil laws are charges brought against the dentist. Charges that are brought against the dentist involve civil law, and criminal law involves wrongs committed against society. Civil charges are brought against a defendant by the plaintiff, who must prove that they have been wronged by the defendant. And criminal charges are brought against the defendant to prevent harm to society. Statutes are enforced by each state's government in the form of a Dental Practice Act, and any employee working in the dental office is covered in this law. So these are dental team members' duties and functions, as they can either be licensed or non-licensed, and they are all covered under the Dental Practice Act. And the Dental Practice Act explains what duties are allowed, which includes expanded functions for dental auxiliaries, and also state guidelines are determined by each state. So these identify grounds for suspension for each state's Dental Practice Act. The State Board of Dentistry is responsible for enforcing the Dental Practice Act for its state. The board responsible for enforcing the Dental Practice Act is the State Board of Dentistry. Each state governor appoints their own board. The membership consists of a majority of or licensed dentistry in conjunction with at least one lay person from the state. The board examines applicants and grants licenses if the criteria is met. Individual state boards are also responsible for the requirements for certification, licensure, and registration. All dental assistants are responsible for maintaining their skills through continuing education. The requirements for continuing education are also determined by the state board. Reciprocity is allowed without further testing or examination. So for example, if somebody was licensed to practice dentistry as a dental assistant in California, they can use reciprocity to gain all of their certifications and licenses in Arizona or Nevada or wherever state that they go to. It usually has to border the state where you're originally licensed. And this will allow that person to practice in the next state without having to go through any additional testing or any additional courses. Expanded functions encompass specific advanced tasks that require increased skills and responsibility. These are outlined by the State Board of Dentistry. General supervision means that the dentist is to diagnose and authorize the work to be performed on the patient by the dental auxiliary, but the dentist is not required to be on the premises while the treatment is being completed. Direct supervision requires the dentist to be physically present in the treatment facility to authorize this function and must be available within an immediate distance to respond to the patient's need and must evaluate the performance of the procedure. So if a patient files a lawsuit against the dentist, what is the patient referred to in this case? They would be the plaintiff, and the dentist would be the defendant. Dental assistants are agents of the dentist, which means a dental assistant, whatever a dental assistant does and says can be used in a court of law against the dentist. So there's a term called res gestae, and this basically means that this is part of the action. So whatever the dental assistant says is considered res gestae, and this is admissible in a court of law. So the dental assistant should be cautious with his or her actions and words at work, as they may become binding on the dentist. A contract agreement must be between two competent parties, which means people who are mentally competent, not under the influence of drugs or alcohol, and at the age of consent. So they have to be at least 18 or over. And they must be, this agreement must be there, or a contract must be there in order to do or not do something legal in exchange for some type of payment. And the contract can either be implied or expressed. Express contract is agreed upon in written or verbal form, while implied contracts are implemented by actions. Most dentist-patient contracts are implied. So which means if somebody opens their mouth, they are implying consent for the dentist to go ahead and go in their mouth and do an examination or whatever else needs to be done. If a patient sits down in the x-ray chair and allows the dental assistant to place on the lead apron, they are implying that they are agreeing to have these x-rays taken on them. Whereas an express consent needs to be written and it needs to be signed by both parties. Contracts can be terminated by either the parties involved in the contract, they can be terminated by either party involved in the contract. This occurs if one party of the contract does not meet the terms of the contract. This can be accomplished if the patient discharges the dentist withdraws from care of the patient, or all of the contract terms have been met and are no longer needed. So the patient no longer needs treatment because all of the treatment have been completed. The failure to provide due care and dental treatment is grounds for malpractice. Negligence is injury caused by one's failure to live up to the normal standard of care. Negligence is a primary cause of malpractice suits. So there are 4 Ds that kind of have to do with malpractice. So this is the duty where the dentist has a duty to provide due care under the standard of care to the patient, and they cannot be derelict, which means careless. So if they fail to adjust a bite correctly, or they leave something in a patient's mouth or inside the patient's tissues that can cause harm, that is a type of derelict. Or if it causes some type of damage, it's a type of negligence, which is a type of malpractice. The duty of the dental team is to provide a high standard of care. A tort is a wrongful act that results in injury to one person by another. So a tort must have a wrongful act that is a breach in due care that actually causes injury because of this action. Some wrongful areas of negligence may result in torts when a standard of care is not followed. So I want to kind of bring a little bit more attention to a tort. So if somebody does something that is negligent and it does not result in injury or damage to the patient, it is not considered a tort. So for example, if an assistant fails to wash their hands correctly, which is a breach in a sepsis, and it causes the patient to have some type of infection, this is a tort because it's damage or injury to the patient. If they break that chain of sepsis and nothing happens, there is no, for whatever reason, nobody got an infection and the patient walked away healthy, this is not a tort. The basis of tort of assault and battery is a threat of unprivileged touching of one person by another without consent. So assault is a threat of touching a person without consent. So if a if there is a pediatric patient, for example, that's in the chair and they're being unruly, and the dentist or the dental assistant threatens to strap them down, or they threaten to hit them, for example, that would be assault because they're merely threatening to touch them without consent. Battery is the act of actually touching of the person without consent. So if a dentist or a dental assistant grabs down a patient or hits a patient after they've threatened them, they've committed assault and battery. Unwanted exposure or publicity of personal records is an invasion of privacy. Personnel must not use any information about the patient without permission from the patient. Insurance fraud is the most common form of fraud in the dental office. The Good Samaritan law is for individuals who are not seeking payment but are rendering a medical assistance to the injured. So this is protection for those individuals in cases of an emergency, like CPR. So if this person is out in the street and collapses, and somebody from the dental team is certified in CPR, they can go ahead and administer CPR to the patient without the fear of being sued because they broke the person's ribs while they were giving them chest compressions. So that is a law that was enacted so that it gives protection to somebody that is providing some type of emergency service, and they're not seeking fees or any monetary value. Mandatory reporting about child abuse laws allow the state to qualify for funding and meet the criteria under the Child Abuse Prevention Act, which is abbreviated as CAPTA of 1996. Every state requires certain professionals and institutions to report suspected abuse. Included are providers of medical, dental, mental health care, and teachers and other educational personnel. Social workers are also involved, as well as law enforcement personnel. So failure to report suspected child abuse and neglect can result in civil or criminal liability that may be punishable by a fine. So if we ever see any type of child abuse or neglect, like bruising, things like that, we are obligated to report these things. Otherwise, we can actually be fined and punished. So abuse are behaviors used by one person in a relationship to control the other person in the relationship. These can be emotional abuse, domestic violence, or elder abuse. In the dental office, the staff may see signs of abuse and have conversations with the patient indicating abuse. The patient may appear withdrawn, have physical bruising, broken teeth, etc. Abuse of a person 65 or older is defined as elder abuse and may come from caretakers or family. This presents a problem to those who cannot care for themselves. They find it difficult to speak up for themselves, especially if the abuse comes from their family. The dental office staff should be aware of signs of abuse and violence and be prepared to refer or assist the patient in obtaining help with the situation. The Americans with Disabilities Act nationally mandates that individuals will not be discriminated against because of their disabilities. In the dental office, ramps and wheelchair access are essential, as well as telecommunication services or a translator if need be. So another dental check here has to deal with privacy. And this one says a dental assistant is having coffee with friends and begins to discuss the procedures someone they know came into the office to have done. What standard of care has this DA violated? That would be the invasion of privacy. So dealing with informed consent. With informed consent, the patient has been made aware of procedures as well as the risks and benefits involved and the expected outcome. It is advised to receive a consent form signed by the patient when any surgical procedures are to be are to be performed. The informed consent form ensures that each patient understands any procedure to be performed in words that are understandable. The patient is made aware of the risks, the expectations, and other treatment options that can be available for the condition they're being treated for. Implied consent can happen in a number of ways in which the patient is implying consent through his or her own actions. So a patient opening his mouth, once again, implies for the dentist to begin treatment. Subpoenas and court orders mandating that an individual show up at a specific time and date and with a specific reason, with a specific reason to testify in a court of law. The statute of limitation defines the period in which the legal action will take place, and each state has their own statute of limitations. Ethics refers to what is considered right or wrong. The American Dental Association Principles of Ethics dictates the code of ethics in dentistry. Advertising is becoming more popular in the dental profession, but used to be thought of as unethical. Satisfied customers are still the best advertising source. Professional fees and charges are based on what is customary to the locale and should represent the difficulty in the procedure. Insurance processing and missed appointments could result in fines. So if the dentist takes the patient and agrees to treatment, the dentist must provide care in a timely manner unless he or she is given notice or is given written notification of possible delays. So the dentist cannot refuse service based on race, color, religion, national origin, or sexual orientation. Also, dentists cannot refuse services because the patient has HIV. Also, dentists cannot be influenced by personal gain, so they cannot be bribed to do anything. HIPAA is the Health Insurance Portability and Accountability Act of 1996. This was originally known as the Kennedy-Kassenbaum Act, and it was enacted as safeguards for electronically transmitted transactions. HIPAA laws are designed to protect patient rights and are enforced nationally by the ADA. HHS was mandated to adopt national standards for electronic administrative and financial healthcare transactions. Dental offices are required to be compliant with codes and are enforced by the Centers for Medical and Medicaid, otherwise known as CMS. The Office for Civil Rights, or the CR, serves as an enforcement authority. A privacy officer should be appointed to keep track of HIPAA policies and procedures. So a privacy officer is somebody that reviews HIPAA updates routinely, checks with the ADA repeatedly to ensure compliance, educates and trains the staff based on any updates by the ADA, and evaluates areas of concern. They should also create a plan to follow up and monitor the compliance. CDT codes have to deal with current dental terminology, and the latest version of the CDT was released in 2011. The first code was completed in 1969 and was initially revised every 5 years, but now it's revised every 2 years. There are 12 categories in the code standard, and each is denoted with the letter D and a 4-digit number. Physicians must claim in standard format, and practices with fewer than 10 employees are exempt from this law. The HIPAA provisions apply to all direct and indirect providers of healthcare services and supplies. HIPAA provisions apply to any business associate transmitting health information in electronic form. Those businesses that provide services for the direct providers must comply with HIPAA rules as well. So there are direct providers, and this is a covered entity. They have to deal with hospitals, clinics, assisted living facilities, physicians, dentists, and alternative medicines. Indirect providers would be providers that have to deal with direct providers, but are not necessarily providing direct care to the patient. These are laboratories, pharmacies, surgical centers, and any others dealing with patient information. The dental practice must inform all contractors that they must comply with HIPAA. Good judgment must be used in selecting associates to ensure privacy. Protected health information, otherwise known as PHI, encompasses any information that can be used to identify an individual, such as names, nicknames, phone numbers, fax numbers, email addresses, social security numbers, student IDs, photographs, oral health information, birth date, appointment date, or geographical identifier, as well as identifiable health information, including past, present, or future health conditions or payments. Confidentiality of patients must be maintained and is the foundation of HIPAA regulations. Unattended records should be locked or out of sight. Computer screens should be turned off. Day sheets should be covered and appointment books should be closed. Fax machines need to be in an area accessible only to staff. So this is really important, especially in the dental office where we have computer screens basically in every operatory that may have patient x-rays, they may have the daily appointments displayed. So it's really important that all of these windows on the screen be closed in between patients. So as soon as the patient walks out of the room, it's your obligation to close out any x-rays, make sure there is no charts on the screen that have to deal with the patient's information, and especially schedules. We never want to have the schedule in front of the patient. So some offices will actually post their daily schedules on the wall somewhere. If this is an area where a patient has access to, like in the hallway or behind an operatory, it should be placed in the inside of the cabinet where the cabinet door has to be opened. Or if it's not placed inside the cabinet or is posted on the wall, it's usually customary for the schedule to be printed upside down and facing the wall, so that if somebody in the staff needs to take a look at it, they have to flip it up to be able to see the appointments for the day. So dental offices write their own policies and procedure statements and are required to supply patients with this information. Patients may view their files, request copies, or ask that certain corrections be made. Privacy policies and procedure statements must be provided to patients, and there is a HIPAA privacy kit that is provided by the ADA that can kind of guide the office on how to do this. The use of PHI is a permitted use. Well, the permitted use and disclosure of PHI can be used for treatment and care coordination or payment, sharing with friends and families identified by the patient, as well as public health offices like the CDC. Patients have the right to an understandable written explanation of their information, use, and disclosure. For example, all instances in which health information has been disclosed for something other than treatment, payment, or health operations. Patients may also make complaints about violations without being afraid of repercussion. Only reasonable needed information should be released from the dental office to minimize the risk of disclosure. Consent requirements must be in plain language. They must inform the patient of practices that are going to be used. Patients have the right to review all of these practices before signing. Notice may change. Patients have the right to restrict use and disclosure. They also may revoke consent at any time, and the consent has to be signed and dated. The security rule dictates that information must be protected from disclosure to unauthorized individuals whether it be accidental or intentional, and prevents alteration, destruction, and loss. The Office of HIPAA Manual includes much of the information necessary to enact HIPAA. It contains the HIPAA training plan, completion dates for each employee, business associates and their audit forms, the policy statement for privacy, and job descriptions for each employee. HIPAA forms and supporting documentation, violation reporting, and confidentiality agreements are also included. It's a good idea to evaluate how FI is handled and what measures can be taken to ensure compliance to the HIPAA privacy standard. The Office of Civil Rights of the Department of Health and Human Services polices HIPAA. Any person or employee may file a complaint without the fear of being punished. Dental offices must self-monitor and self-evaluate the HIPAA practices and be responsible for complying to the rules. Civil monetary penalties that are non-criminal violations, including disclosures made in error with no intent to violate, are can be $100 per violation, or up to $25,000. There are criminal penalties for knowingly violating privacy and range from $50,000 and 1 year of imprisonment to $250,000 and 10 years of imprisonment. So for somebody that discloses information under false pretenses, there is up to a $100,000 fine, as well as a 5-year prison sentence. For somebody that intends to sell, transfer, or use information for commercial gain or intent to maliciously harm a patient, there is up to a $250,000 fine, as well as a 10-year prison sentence. So here's our last dental check for this chapter. Can a healthcare provider go to jail for violating HIPAA regulations? The answer is yes, especially if the violation is intentional, and especially if the violation is used with intent to cause harm. Okay, so that's everything I have for chapter 3. Please let me know if you have any questions. Thanks for listening.